Welcome back to the Constitutional Clarion. Ever since Guy Fawkes' failed gunpowder plot of 1605, governments have had to consider how do you go about reconstructing government if, in a catastrophe, you lose all those who have legal and executive authority. There needs to be some kind of underlying chain of command, or perhaps more accurately, a chain of governance, so that there is always someone with legal authority to be able to act to restore the operation of the democratic system. For example, you'd need someone who would be able to call an election and issue the writs that command people to hold those elections so that you can elect a new parliament. This video is about that chain of command, or the chain of governance, which is rarely considered by the public, but it is very important that it exist. In the United Kingdom, there is, of course, a line of succession to the throne, which extends a very long way, so that there is always someone who can exercise the monarch's powers and can take action where necessary to restore the democratic system. In the United States, there's also a presidential line of succession, and this appears frequently as a plot point in novels and in television series. So, for example, Designated Survivor was based on it, and there was even the odd episode of Veep that referred to that chain of succession. But what about Australia? First, there is no designated line of succession for the Prime Minister. Sometimes we have a person who holds the title of Deputy Prime Minister, but this does not automatically make them Prime Minister if the Prime Minister dies or resigns. It's a matter for the Governor-General under Section 64 of the Constitution to appoint the Prime Minister. And according to convention, the Governor-General appoints the person who is most likely to command the confidence of the lower house, the House of Representatives. That is ordinarily the leader of the party or the coalition of parties who hold the majority of seats in the lower house. If a Prime Minister dies in office, then in practice it's a matter for his or her party to decide who should be their leader, and this indicates to the Governor-General who is the person who is most likely to command the confidence of the lower house. But party processes can be slow. The Governor-General has in the past, therefore, appointed a Prime Minister who filled the role temporarily until such time as a new party leader was chosen, whereupon the interim Prime Minister voluntarily resigns and the new leader is appointed Prime Minister. 3 Australian Prime Ministers have died in office. The first was Joseph Lyons, who died on the 7th of April 1939. He was the leader of the United Australia Party, which at the time was in coalition with the Country Party. At that time, the position of Deputy Leader of the United Australia Party was actually vacant because Robert Menzies had resigned from it after a policy dispute. The Governor-General, not acting on any ministerial advice, by the way, appointed the leader of the Country Party, so that's the minor party in the coalition, Sir Earl Page, to be Prime Minister until the United Australia Party appointed a new leader. Page served as Prime Minister for 20 days. By appointing Page, the Governor-General avoided any accusation of favouritism that might have flowed if he had appointed someone who was a candidate for the leadership of the major governing party. Page steadied the ship and resigned as soon as the United Australia Party appointed its new leader, who was indeed Robert Menzies. Next, the Labor Prime Minister, John Curtin, died on the 5th of July 1945. He was replaced for a short period by his deputy, Frank Ford, until the Labor caucus chose its new leader, Ben Chifley. The most interesting case, however, was that of the Liberal Party Prime Minister, Harold Holt. He went missing while swimming in the ocean on the 17th of December 1967. Now, foreign viewers here might be fascinated to know that Australia was actually so careless as to literally lose a Prime Minister in the sense of not actually knowing where he was. And then, after he was later presumed to have drowned, to name a swimming pool after him in his electorate. I do remember as a child being absolutely flabbergasted when we once drove past the Harold Holt Memorial Swimming Pool, knowing that he was a Prime Minister who had drowned. In the absence of proof of Harold Holt's death, because, as I said, they never found his body, there was an issue about whether there was a vacancy in the office of Prime Minister. The Governor-General, after consulting the Chief Justice of the High Court, formally terminated the appointment of Holt at 10 p.m. on the 18th of December 1967. The Governor-General faced the dilemma of whether to appoint as Prime Minister Holt's deputy leader of the Liberal Party, William McMahon, or the Deputy Prime Minister, who was the leader of the Country Party, John McEwen. As McMahon was a likely candidate for the leadership, and as the Country Party so distrusted him that it refused to work with him, the Governor-General appointed McEwen as Prime Minister on the basis that he would step aside once the Liberal Party chose its new leader. The Liberal Party chose John Gorton to be its leader, even though he was a senator at the time and therefore was in the wrong house. Convention demands that the Prime Minister sit in the lower house. So after he was appointed, Prime Minister Gorton resigned from the Senate and ran in a by-election for Holt's seat, which he won. He therefore served as Prime Minister while first in the Senate and then without a seat at all, and finally as a member of the House of Representatives. Section 64 of the Constitution facilitates this because it provides that a minister shall hold office for no longer than 3 months unless he is or becomes a Member of Parliament. The interim by-election in this case was held less than 3 months later, so he had no problem. Now, for the viewer who actually asked what happens if the Prime Minister becomes mentally incapable and whether there was a way under the Constitution of removing him or her, the answer is that it's up to their colleagues to do this. Political parties have become quite brutal in getting rid of their leaders who have lost popularity or taken eccentric decisions, such as knighting Prince Philip, or shown personality traits that are inconsistent with good leadership. The House of Representatives could also pass a vote of no confidence in a Prime Minister if it believed that he or she was no longer capable of doing the job. Going back to our Armageddon scenario, what happens if there are no members of Parliament at all? It is up to the Governor-General then to take action to initiate an election and perhaps also to appoint interim ministers who could serve for a period of up to 3 months before losing office if they had not by then gained a seat in Parliament. But what happens if there is no Governor-General? Is there a chain of command? And the answer here is yes. Section 4 of the Constitution provides for the appointment by the monarch of a person to administer the government of the Commonwealth in the absence of the Governor-General. Now, this may occur if the Governor-General dies or resigns or is travelling outside Australia or is sick or incapacitated. In practice, state governors are given what are called dormant, so sleeping, commissions to administer the Commonwealth. Sometimes it's the practice that the most senior available state governor then fulfills the role. Other times there has been a preference for a particular governor or governors from particular states, so it depends upon the personalities involved. Those of you who are 1975 dismissal aficionados might remember that in the month before the dismissal of the Whitlam government, Prime Minister Whitlam advised the Queen to remove the dormant commission of Sir Colin Hannah, the Queensland Governor, to act as administrator of the Commonwealth. Hannah had given a speech that referred to the fumbling ineptitude of the Whitlam government in October 1975. As the Governor-General, Sir John Kerr, had planned an overseas trip, Whitlam was concerned that this supply crisis could come to a head when Sir Colin was administering the government. He much preferred to have Kerr in charge because he thought that Kerr was someone he could control. Not so much as it turned out, in fact. So Whitlam, against the advice of the Attorney-General's Department, advised the Queen to withdraw Hannah's Dormant Commission, which the Queen did on the 24th of October 1975. As it turned out, Kerr cancelled his travel plans, and having seen how Whitlam dealt with Hannah, became convinced that Whitlam would also advise the Queen to withdraw Kerr's own commission if he gave him warning of dismissal. And thus we see the dismissal unfolding without any warning being given. But what about the state governors themselves? What happens when they, or one of them at least, is fulfilling the role of the Governor-General, or if the governor is otherwise absent from the state or incapacitated or there's a vacancy in the office? Is there a chain of command? Again, the answer is yes. Traditionally, the chain of command has gone through the legal system, relying on the order of seniority of judges. So in New South Wales, for example, and I might add some of the other states do this differently, but in New South Wales, the Chief Justice of the Supreme Court is the Lieutenant Governor, who administers the state in the Governor's absence. But if the Lieutenant Governor is not available, then there is an administrator, who is the President of the Court of Appeal, followed by all the judges in their order of seniority. On the one hand, this is a good system because there's a clear line for the transfer of authority, there are many people in that line, and those who might get to exercise the authority are trained in law and understand their constitutional role. They're also professionally trained to behave fairly and to act according to the law rather than what they personally want the outcome to be. If a catastrophic situation arose and you needed someone who could use their legal and executive authority to restore the system of representative democracy, then a senior judge is probably a good person to call upon to do it. On the other hand, there is a separation of powers issue if judges are exercising executive powers and powers related to the legislature, such as assenting to legislation or giving messages, approving appropriations in Parliament. From a constitutional point of view, the separation of powers, of course, does not apply at the state level. Nonetheless, as state judges do also exercise federal jurisdiction, the courts have held that they have to retain decisional independence from the executive. So far, the courts seem to have accepted that the exercise by a judge of the role of administrator of a state is a long-standing historical practice which is valid, albeit anomalous. Potential conflicts are managed by the relevant judge not sitting on challenges to laws to which they assented as administrator or to other actions such as decisions made on applications for mercy. For example, when the Chief Justice of New South Wales as Lieutenant Governor acted upon the advice of the Premier to dismiss a minister, and that minister later challenged his dismissal in the Supreme Court, the Chief Justice obviously did not sit on the case. While the use of judges to exercise the executive powers of the Governor as part of a chain of governance is constitutionally awkward, I think this is probably outweighed by the advantage of having a long identifiable chain comprised of suitably trained people who would be capable of dealing with a catastrophe and restoring representative democracy if needed. And I should just flag here that I do have a bit of a personal interest in this. My husband is a judge who potentially could act as administrator of the state of New South Wales, although hopefully never in a catastrophe. Has anyone in Australia thought about and prepared for how to deal with a catastrophe where the government and the parliament are wiped out? The answer here is yes. Terrorist attacks and natural disasters such as tsunamis have caused people in government to think about what would be needed and how to deal with it. I came across this once when I was asked for some advice about the seal of the state and whether or not they were able to have an alternative spare seal prepared and, I don't know, buried somewhere out near Bathurst or something like that. So yes, people have been making contingency plans, but hopefully they will never have to use them. And there is a chain of governance to manage the situation if the worst happens. Thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.